Great. Thanks, Anthony. Yeah, I think it is important to kind of discuss the background of what is PAGA, because if you don't have familiarity with it, you may wonder what the big deal is and why this is even up at the Supreme Court. Since it's a law that doesn't impose any kind of new substantive requirements of how you have to treat your workers or anything like that, but it nevertheless has a profound impact on all of the rest of the labor code. And California has a pretty substantial labor code, as if you've been an employer in California, you already know. PAGA was designed by the legislature to offer financial incentives to private individuals, current or former employees, to enforce the state's labor laws by recovering civil penalties that only the state could recover. And part of the justification that the legislature had was, the state agencies that are supposed to enforce the labor codes are understaffed and under-resourced. And so in the view of the legislature, there was a lot of violations of the labor code and not a comparative amount of enforcement by the state. And so they designed PAGA to try to fill that gap. And so for that reason, the civil penalties that a plaintiff can recover in PAGA are, in addition to the other damages and penalties that an employee can receive on their own. For example, if an employee is not provided a meal break, they have personal individual damages of an hour at their regular rate of pay, but PAGA adds an additional civil penalty that could be charged to the employer on top of the employee's individual claim. And so aggrieved employees can recover civil penalties for labor code violations, not just the one that they suffered, but any other labor code violations that they can prove against the employer. And so it's a way where, if an employee can prove that they had one labor code penalty or violation against them, they can recover an expanded set of violations. If they have a rest break violation, they could then use that to seek PAGA civil penalties for other employees who had maybe meal reimbursement violations or overtime violations. And so what PAGA did was, for labor code provisions that did not already have an existing civil penalty, PAGA set a penalty at $100 per employee per pay period for the first violation, and $200 per pay period per employee for any subsequent violation. And so any penalties that are recovered under PAGA, 75% of the penalties go to the LWDA, the state agency, and the remaining 25% is distributed amongst the employees. All of this is after the plaintiff's attorney's firm takes their cut, but it's a distribution where most of the money goes to the state and a percentage goes to the employees. And so the example that was cited by an amicus brief in the Supreme Court case showed how PAGA penalties can really add up. And so it talked about, if an employer has 100 employees and they have weekly pay periods, and let's say there was 2 years at issue, that would be approximately 100 pay periods multiplied by 100 employees would mean 10,000 pay periods. And so the penalties are on a per pay period basis. And so if you have meal breaks, a $50 penalty times 10,000 pay periods, all of a sudden you're at $500,000. You add missed meal breaks, off the clock work, overtime, inaccurate wage statement, unreimbursed cell phones, add all that together, and suddenly you have a claim for $5 million plus costs and plaintiff's attorney's fees. And I think something that really kind of shocks to employers a lot is the combination of these different things means that it's not unusual. We've seen that an employer says, this guy worked for us for 3 weeks as a dishwasher, and he left, and then now he's suing us for $5 million. And kind of that is what PAGA has presented to employers, the combination of those issues.